This Honorable Court of Criminal Appeals is now in session.
Thank you, Madam Clerk. Good afternoon, everyone. This is the May docket for Knoxville and the Tennessee Court of Criminal Appeals. As you know, we handle these cases in 3-judge panels. Today, it's my privilege to be the presiding judge. My name is Robert Wiedemeyer. I live here in Nashville. I'm one of the middle section judges, and my two colleagues are both from the western section, Judge Camille R. McMullen and Judge J. Ross Dyer. So it's my honor to serve with them on these cases in Knoxville. We are all, of course, looking forward to getting back to our regular routine in the courtroom, but until that time, and over the past year or so, we've been very grateful and are still grateful to the Administrative Office of the Courts, Barbara Peck and her staff, and Ms. Tate, and because they've allowed us to access the technology to be able to continue hearing oral arguments the way we're doing it, the way we're going to hear them today on the Zoom platform. So we preliminarily, everybody probably knows this, each side gets 20 minutes. If the appellant wishes to reserve some time for a rebuttal argument, please let me know and I'll try to help you keep up with your time so that we can take care of that. We have read the briefs. So we're knowledgeable about these cases to that extent. We have not been assigned or carefully studied the actual records, which we, of course, will do so before we make a decision. But I think that's all the preliminary matters I have on this docket for the afternoon. Madam Clerk, do you know of any preliminary matters?
No, sir.
All right, just call the next case for argument, please.
State of Tennessee versus Richard Williams, Kipling Colbert Jr., and Christopher Bassett Jr.
All right, let's see. We have 3 defendants, and I'm looking at my docket sheet and I see several attorneys. How about whoever is planning on arguing first, let me know what the plan is from the appellant standpoint.
Your Honor, T. Scott Jones, and from the appellant standpoint, I personally represent Christopher Bassett. Obviously, Gerald Gully Jr. represents Richard Williams, and Rhonda F. Lee represents Kipling Colbert. They have been kind enough, subject to this court's approval, to allow me the 20 minutes that we've been allocated to argue the points that we share in common, particularly the evidentiary issues with regards to the rules of evidence and particularly the First Amendment issue that's somewhat novel and unique in this case. I would request that I be allowed to reserve 5 minutes, that my opening be 15 and obviously 5 for response.
All right, thank you, Mr. Jones. That plan is perfectly fine with the court, and Mr. Gully and let's see, Ms. Lee, we appreciate both of you being here for the oral arguments. And that being said, Mr. Jones, you can begin whenever you're ready, and I'll let you know when you've reached 15-minute mark.
Thank you, Your Honor. May it please the court, appreciate obviously your time and attention. This case presents somewhat of a novel issue in that the Tennessee court is being asked to examine both the applicability of the rules of evidence, which we all, hearkening all the way back to law school, familiarized ourselves with, but also the intersection of those rules of evidence with the First Amendment rights shared by each one of these individuals. And of course, obviously, I'm arguing on behalf of Mr. Bassett, but there's a shared interest with regards to Mr. Williams and Mr. Colbert. Not much question that it is a terribly unfortunate loss of life, and that a young man lost his life as a result of an incident that occurred in December of 2015. These gentlemen came, of course, we've outlined in detail the, if you will, procedural history of how they each respectively came to be charged. But in the unique thing, and that's what I've been tasked to argue to the court, we have the situation with regards to the rap video. That in and of itself, if it was used for appropriate purposes, might not have caused a problem. However, in this particular situation, it was utilized by the state, basically, despite our repeated and vigorous objections to the same, both in pretrial written motions and in motions made at the actual trial of this cause, which took a considerable amount of time, particularly with regards to whether or not it even met the 401 test of relevant evidence, and then incorporating in the 403 test of whether or not any probative value that it might have or relevance that it might have was so grossly overweighed by its prejudicial effect. There is no question, at least from the trial court transcript and obviously from my having represented the individual, Mr. Bassett, that this video was made in May of 2015. May of 2015, some 7 months before any of these lives intersected in the unfortunate circumstances that resulted in the demise of Mr. Dobson. That being said, there's no legitimate argument that it's made as far as a testimonial type video, i.e., it is a rap about something that had previously happened. And so we actually enlisted the expertise of a renowned expert, Eric Nielsen, with regards to this particular rap video. We furnished the court a large amount of information pertaining to the same, particularly with the fact that it was Chicago drill type rap. That being said, the artist upon whom this original, this video that these defendants were in was actually a fellow by the name of E-Day. And this is, again, Chicago drill type rap. Now, they took and they, if you will, purloined the, the underlying rhythm associated with it in some of the lyrics and then adapted the lyrics. What makes this particularly, interesting is, it's just simply not relevant to the case at hand.
Counsel, can you speak to the state's preliminary argument that it is relevant for purposes of identity and motive?
Yeah, we certainly can, because the state sort of addresses what I consider to be a first-time argument. That argument was never actually expressed in response to the motions that we filed, nor in response to argument that we put forward at the trial of this case. We would consider it pretextual in nature, and I know what you're referring to. You're referring to that Devontae Patrick, who was a witness in this particular case, says that, hey, I happened to watch a YouTube video and I pointed out there's that guy. And,
right.
We sit there and we look at how do we identify.
And counsel, and the fact that that guy approached him and asked him or used gang terminology.
Well, when you actually get to the testimony, he had actually made the statement to his grandmother, and the statement comes out, there's a divergence in the testimony. You're talking about the what's bracking and those type situations. In the original reference to it was what's cracking. And of course, we're getting into the gang parlance that basically the Bloods will not use words that have a C in them. They will, basically substitute a letter associated with that. That problem comes into the effect that why didn't they use a driver's license photo for identification, any other type of photo, a high school yearbook? All of these were available to the state, or even arguendo, if they wanted to say, hey, let's use the video. Why didn't they use a still shot of the video? Why did we play not once, not twice, but thrice the video in front of a jury that shows young men expressing themselves artistically 7 months before? And admittedly,
that may be true. You have me there in terms of your argument. However, what I'm concerned with is the state's position is that this was basically a gang. There were multiple shootings, from what I gather, and I'm going to need a diagram to figure out
There were
all the shootings
three
and the connections. The
shootings.
state's, if you let me finish, the
Yes,
state's
ma'am.
position is that in order to explain the motive behind these shootings, at least what I understand from the briefs, is that this was all motivated by a gang rivalry. And so the video was part and parcel of their theory in showing and establishing motive. And I don't want to eat up your time, but that I need for you to speak to that for me.
Absolutely. Let me address that first off by saying that the state called a gang expert, a gentleman by the name of Tom Walker, who actually testified that in his entire career, he had never been called to testify in a case, and he would testify that the folks had no gang affiliation. There is no gang tie relative to this. Also, he testified with regards to the period of time that Mr. Bassett in particular was incarcerated and the others, there was no evidence of any gang communication. So that being said, he likewise said that gang members do not prey upon non-gang members or generally random type parties or random type violence. So then that kind of flies in the face of the whole gang thing. I mean, that's why we were tying it in, that it was basically used to scare this jury, to frighten this jury, and to prejudice this jury. And then we get into, of course, the 403 argument as far as any value that it might have or relevance was so outweighed by its prejudicial. That's why I was suggesting with regards to the driver's license, yearbook photos, other photos that were available, mainly because not one of the defendants, we didn't question Devontae Patrick's ID. That wasn't questioned with regards to it. And then the other aspect of it, when we asked Mr. Walker and we asked the expert associated with it, does rapping about guns and gang life make you a gang member? And it does not. And the fact that this drill type rap, a lot of times what the expert testified to it is that you are living an alter ego. You are living something, if you will, almost Walter Mitty-ish, in that you are expressing yourself through your art with regards to what you're surrounded with and what you're dealing with. And hence we, of course, use the, quintessential examples with regards to these folks being studio gangsters. The fact that Johnny Cash, you know what I mean? I shot a man in Reno just to watch him die. Our own beloved East Tennessee heroine. And of course, we would use that these type artistic expressions or imagination. That's Dolly Parton. And she talked about stabbing her lover in the heart. In one of her songs, her lover's lover, sorry. That being said, that didn't come out right, but that was the general.
But let me ask
premise.
you this.
Yes,
If Dolly Parton had killed her lover's lover by stabbing him in the heart, do you not think that, and that song was written in the general time period of her committing that crime, that's not relevant?
It would be relevant, but not when it's written 7 months before, and it's actually a takeoff of E-Day's song 600. It's not a.
But if I understand if I understand from reading the briefs, the state's theory, and Judge McMullen kind of alluded to this at the beginning of our questioning, is that this series of crimes, these series of events were gang retaliation from one side of Knoxville to the other. And I'm not going to get it correct right now asking my question, but someone on East Knoxville gets shot. So these guys from East Knoxville go to West Knoxville to shoot somebody. And then when that person gets shot, the people from West Knoxville go back to East Knoxville and shoot someone. And it's all based on Crips and Bloods. And in this video, not only does one of the witnesses identify one of the defendants, but then two, here he is with other individuals wearing gang colors, throwing gang signs, holding guns, or whatever all's in the video. Obviously, we have not seen it. But does that not go to the state's theory, and therefore it's relevant whether the jury wants to believe it, whether they want to believe that Dolly Parton would stab her lover's lover in the heart? That's not relevant, so to speak. Whether or not it's relevant does it go to what the theory and the proof of the case is? They don't have to believe it. They don't have to believe the gang expert. If the
But
gang
what's-
expert says, well, this isn't what normally would happen, the jury could either go, oh, well, then the video doesn't matter, or the jury could say, we don't care what the expert says, it matters to us.
But what's rapped about is not similar in any shape, manner, or form as to what happened. What's rapped about is
But I'm not talking about the
particularly
words.
a
I'm talking about
drive-by. Well, I
I'm talking
got
about the
it, but
individuals. What makes it relevant is the individuals in the video are holding themselves out, as I understand it, as gang members wearing the same colors, throwing the same gang signs. And then this is, as I understand the facts, one side of town shooting up the other side of town, two different gangs, and these guys are in one gang. What they're singing about, maybe that isn't relevant, but the fact that they're together acting as gang members, holding themselves out as gang members is relevant.
well, respectfully, I don't think that's what the facts come out in this particular case. That would be a broad stroke view and an argument that the state would try to put forth by using this video effectively to scare folks. But then how do you tie that in when there's no gang tie-in, like L0, nothing with regards to any of these individuals being involved with a gang in any way, shape, manner, or form? I mean, it's basically fiction. That's what the video is. It's not fact. And then to sit there and persecute or allow the state to pillory somebody utilizing their artistic expression. I mean, what about somebody that made a movie about murder? How is this any different? You can't differentiate that. While we may not find the particular artistic expression something that we adopt or we appreciate, we can't do that. What about
But the U.S. Supreme Court has already said this isn't off limits.
No, it's not. But, you know, when we read the Dawson case and we look at the other cases, we look at McMillan, we look at those, we look at the fact that no, that they exclude that. You know, somebody's relationship as far as being a member of the Aryan Brotherhood.
They excluded it for sentencing. They didn't know. In Dawson, they excluded it for sentencing purposes. They did not exclude it. Matter of fact, they said it could have been used at trial for certain purposes. So that's what I'm saying. The U.S. Supreme Court has said that artistic expression doesn't give you carte blanche First Amendment protection, that it can be used.
Well, the first test is
sentencing purposes.
The first test is whether or not it's protected by the First Amendment. We all agree it's protected by the First Amendment. It would be disingenuous to argue otherwise associated with that. But then the issue becomes relevancy. So what's it used for? Why do we play it 3 times except to scare a jury? Why do we do that? There is no logical explanation. And then why do we now wait till we're in the Court of Criminal Appeals and then we come up with a pretextual argument that, oh, it was for identity? That was never articulated.
Counsel. That's maybe your better argument, at least for me. And not having read the transcript, that to me is your better argument, that the state waived this issue. Because they did not, that was not what was presented to the trial court at the time that you lodged your objection. I don't think that Dawson is necessarily applicable here because that was the issue of the Aryan Brotherhood, and it didn't have any bearing on the actual killing of the victim in that case. Here, again, we're stressing because we have a limited understanding of the facts. It appears that the video did have some bearing on the facts. And so what you're saying is it didn't. And so we have a factual question here that I think that the court is struggling with.
Right. And I think that factual question, you know, then when the court looks at the facts, Mr. Dobson, Xavion Dobson, was not in a gang. There's no testimony with regards to that. There is no testimony that Christopher Bassett is in a gang. There is testimony that his art is going to be used to create some sort of an implication or something of that nature, and that he was an aspiring artist. But with regards to what you referenced earlier, yes, we would contend that the state waived it. When you look at how they address it in their reply brief to our appellant's brief, I mean, it's pretty clear because that's the first time where it comes up, oh, we had to do this for DePonte Patrick's identification. Well, you know, we have the First Amendment issue, but we've also got 401, 402, 403, and 404. We're basically using this evidence to assassinate the character of Mr. Bassett and these other remaining defendants with regards to it. We think that's the inappropriateness because you have to look at it from an evidence.
And I understand. And I know you've got time constraints, but if it didn't come in for identity and it didn't come in for motive, how did it get in?
That's the question, obviously, that we've objected to. I mean,
What grounds were given by the court?
The court just effectively entered orders that it was overruled and that the video was going to be allowed to be used. I mean, albeit we have all due respect for our jurists, but that's
Sure.
why we have courts of appeals. And we had to try the case knowing full well. And then that's what then bothers me when, if we're going to say it's used for identity, why are we playing it 3 times? Why are we trying to scare that jury? And that's basically the problem that it comes down to. I mean, I think they might have had a legitimate argument, albeit very, very at the best pretextual, that, oh yeah, we used it for identity, and they could have put a screenshot of a small part, but then to use the rest of that video to scare folks. I mean, I think that was basically a scare tactic by the state, because, they kept talking about gang members and wannabe gang members and everything of that nature. But then, why then do you put an expert on, obviously it inured to our benefit, that says nobody's a member of a gang, no evidence of any gangs. And, you don't get to slur somebody with the gang moniker just because it's convenient and it helps your case. I mean, that's no different than, labeling somebody any other way in an inappropriate way. And in this circumstance, we feel like that, then evidentiary looking at it, that certainly the prejudice certainly outweighed any relevance or any probative value with regards to that. So, that is effectively our argument. We've done our best to outline that. Obviously, we have been blessed with the assistance of the ACLU. We've had them participate with us, and they filed an amicus filing. But, when we look at the standards with regards to this, any type of First Amendment type situation, strict scrutiny, but then also we, have basically what I consider to be a very complete record before the court with regards to this. And I think when you look relative to time, I just don't think that video had any basis being utilized in the prosecution of these young men. So,
Mr. Jones, you are into your rebuttal time. I know
I'm sorry.
A lot of questions. Now, I just want to help you keep up with it. You've got 3 or 4 minutes left total. So if you want to save that for rebuttal, fine. Or if you want to keep right on.
I mean, my verbosity knows no bounds, so I better hear from the state.
All right. Well, let me just say that the briefs in this case are just excellent briefs. And I said that earlier on a case where it's a relatively short amount of time with a lot of issues, and but rarely are you going to get in trouble if you rely on your brief as when you write the briefs, as well as all these attorneys have. So, and now my time is up. All right, General, you ready?
Yes, Your Honor.
All right.
Good afternoon, Your Honors, and may it please the court. My name is Garrett Ward, and I'm here this afternoon on behalf of the state of Tennessee in this consolidated appeal of State versus Mr. Kipling, Colbert, Richard Williams, and Christopher Bassett. As the appellants did during my time, I'll focus on the issues relating to this YouTube video.
General Ward, let me just go ahead and ask you
Yes, Your Honor.
2 questions that Judge McMullen posed that to the other side that I want to ask you, is, or at least one she proposed. One is, if it wasn't admitted for motive and identity, why was it admitted? And then 2, I'm gonna go ahead and ask the question that defense counsel like to harp on, which I have a tendency to want to know why as well. If it's for identity, why do you need to play it 3 times in full? Why can't you just use a screenshot and kind of cut out the confusion here?
Certainly, Your Honor. I'd be happy to address that. 2 points to address Your Honor's question. First, this video was challenged pre-trial on relevancy grounds under the Tennessee Rules of Evidence, and the trial court did admit it for motive and story completion purposes. So those
story completion. I've got a senior colleague on this court who picks a bone with that whole race gesti concept and story completion and narrative. And, you know, we kind of backdoor admissibility questions or cover ourselves with that concept. So I'm going to need you to tread lightly when you say story completion.
Certainly, Your Honor, and I say that just to shed light and be candid with this court on the trial court's reasons.
Okay.
In this case, what is clear from the record is that the primary purpose for which the trial court admitted this video was motive. As Your Honors indicated and touched on during opposing counsel's argument, it was the state's theory in this case that the killing of Xavier Dobson was part of a series of gang-related shootings in various parts of Knoxville in the same 24-hour period. And for ease of the court, I'll sort of briefly run through what happened on the day in question, because I think a brief explanation of factually what occurred helps elucidate why this video and why this evidence was relevant for the purposes of motive. So in the sort of early to late evening, around 7 or 8 p.m., a woman by the name of Lisa Perry was non-fatally shot. Her son, Mr. Brandon Perry, is a friend of all three of the defendants here. Mr. Perry, the evidence at trial showed, after his mother was shot, he arrives at the scene. He's justifiably upset. He then, with the three co-defendants in this case, travels to an apartment of another friend of theirs to pick up some firearms. Then the three of them travel into West Knoxville, where they are seen by, or where Mr. Colbert is seen by Devontae Patrick, where Mr. Colbert speaks to Devontae Patrick using some terminology that is gang related. And then shortly after that, Mr. Dobson is shot. The defendants then leave the scene, and shortly after Mr. Dobson is shot, Mr. Perry himself is actually fatally wounded in the third shooting on this evening. So the state's theory at trial, and this is clear from the record, the theory at trial was that these were three gang-related shootings.
What is troubling to me, and again, I qualify my comments with, I haven't dug into the record yet. Counsel's comments that you guys put on an expert saying that this wasn't gang related?
Your Honor, I don't believe when this court goes and reviews Mr. Walker's testimony, Mr. Walker's testimony is not, and none of the other testimony from my recollection at trial is that, oh, there is no gang relation to this case. The two comments which I believe Mr. Jones may have been referencing, Mr. Walker does say that the defendants in this case weren't previously or didn't previously appear in the Knox County sort of gang registry. And then the state also on the record says it's not seeking to use the criminal gang enhancement statute as it existed at the time. But no, Your Honor, I don't believe the record reflects that the state was in any way trying to convey to the jury that there was no gang relation in this case. In fact, quite the opposite. The state theory was that there was a gang related shooting of Mr. Perry's mother, that Mr. Perry and the three defendants traveled to territory of a rival gang to commit a shooting in retaliation, and then Mr. Perry himself was killed in yet another display of retaliatory violence.
And just for my edification, what other proof did you have establishing that this was gang motivated?
Your Honor, there was some signage attached to, or not signage, I guess graffiti and tags attached to a couple of the locations in this case, Mr. Perry's residence where his mother was shot. And then some of the comments of Mr. Bassett during his during his interview with police and the testimony of Larry North at trial. All of these sort of pulled or tugged at gang-related lines.
Thank you. You may proceed.
And Your Honors, I think the state's theory was that this was gang related, and this video directly spoke to that theory. It absolutely had some tendency to make this theory more or less probable, and that's the primary inquiry when we're doing relevancy review under the Tennessee Rules of Evidence. During this video, I'll speak of three things that happened during this video that the state's expert testified were signs of sort of gang involvement of the men depicted in the video. One is the display of sort of gang colors. Two is the making and use of gang hand signs by the singers and performers in the video. And third, and this is probably the most important and most critical piece of information, the most critical item that comes out from the video itself, from the lyrics itself, all throughout this video, which is a rap video with lyrics that the evidence at trial showed were written and created by the defendants. There's the use of terminology that references specific areas of Knoxville and specific Knoxville gang sort of subsets of larger street gangs. So there are multiple references to Knoxville specific subsets of the Blood Street Gang. There's affirmations and statements in the lyrics of this video that the participants identify and associate with the Blood Street Gang. There's some comment about, there's other comments about what this might mean to them. But this video contains, as I've indicated, very, very specific terminology, specific to Knoxville, terminology that wouldn't readily be known outside of sort of having specific knowledge of gangs in Knoxville specifically. So,
but the fact that the video was made, what was it, several months prior to the offenses in this case, impact your argument?
It was made, I believe, 6 or 7 months prior to the incident. Yes, Your Honor. There would be perhaps some impact, but whether this video was made the week before or whether this video was made a few months before, as was the case, the use of this terminology, the display of these colors, the sort of construction and making of these signs, I think even with that passage of time, still speaks to gang affiliation to some extent. So, Your Honor, since the state's theory was that this was a gang-related shooting, or that this shooting, that the death of Xavion Dobson was sort of an unfortunate outcome of a number of gang-related shootings in Knoxville on the night in question, and the video had some tendency to make this theory more or less probable, I'd suggest to this court that it was relevant for the purpose of motive, and the trial court properly admitted it for this purpose.
Well, I don't think you answered Judge Dyer's second part of his question. Why was it played 3 or 4 times? What was the need for that? Isn't that overkill?
So I can speak to that, Your Honor. From my recollection of the record, it's played for when Detective Walker is testifying. Detective Walker was the state's expert here, so it was played during his testimony so that he could explain to the jury what various pieces of terminology in the video might mean. The video was played when Mr. Patrick was testifying. Mr. Patrick was the individual who recognized and saw, or who saw but did not initially recognize Mr. Colbert in this case. and then some months later sees this same YouTube video and makes an eyewitness identification solely after seeing this video. So the video was played at that time to sort of buttress and
Those are the two instances that you recall from the record.
and then I believe there's a third, Larry North, who was an associate of the three defendants, or of the three co-defendants in this case. The video was played during his testimony, and questions were asked of Mr. North about the video creation process, sort of to establish that this wasn't just lip syncing, that this wasn't just performative of somebody else's lyrics, that these were lyrics that had been created and recorded by the defendant. So from my recollection, those are the 3 times this video was played. And for each one of these instances of the video being played, I'd suggest to this court that the state had a proper reason for playing it for these specific witnesses.
Was Mr. North part of the production of the video? Is that what you're saying?
I don't recall exactly what Mr. North testifies to as far as being in. I'm not certain, Your Honor, if he is in the video itself. What's clear from his testimony is that he testifies that he at least knew about the production of the video. So whether he was sort of a bystander or an onlooker when it happened, or whether he was a more active participant in the creation of the video, I can't specifically say, but he does, in his testimony, indicate that he has knowledge of the creation process. Briefly, Your Honors, the defendant's argument seems, at least here at oral argument, to be primarily focused on the Tennessee rules of evidence as it pertains to relevancy. For the reasons I've stated to this court, I think this video is highly relevant for the purpose of motive and the purpose of identity. Given its what I would suggest high probative value for both these purposes, I think this is not a situation where the sort of extraordinary remedy of 403 exclusion would properly come into play. Outside of the Tennessee rules of evidence, Your Honors, the defendants suggest that somehow the First Amendment to the US Constitution operates to exclude this evidence. And they point to chiefly an early 90s case, Dawson versus Delaware, which Judge Dyer, as you noted, is a sentencing case, so arguably would not have application outside of that context. And that viewpoint, I believe, is advanced by the Supreme Court's knowledge in a case published the year after Dawson, Wisconsin versus Mitchell, where the court sort of unequivocally states the First Amendment does not prohibit the consideration of protected speech for purposes at trial of motive, elements of the crime. Essentially, the First Amendment does not prohibit the use of speech for evidentiary purposes. The defendants rely on this sort of concluding one line from Dawson and attempt to expand Dawson to be both some larger test, wherein the First Amendment does have some part to play in considering whether or not evidence might be admissible. They suggest both before this court at argument and in their briefs that strict scrutiny be applied in this situation. It's unclear from their argument. Seemingly strict scrutiny would be applied to the Tennessee rules of evidence here. And I don't find any support in Dawson, and certainly in no other jurisprudence suggesting that this sort of First Amendment framework can or should be applied in this evidentiary context. The Supreme Court is very clear in Mitchell that the First Amendment does not prohibit the evidentiary use of speech. And this makes good sense. Most of our criminal trials involve the use of speech that all parties agree is protected by the First Amendment, involve the use of that speech as evidence. Although here we're dealing with artistic expression, I don't believe that changes the calculus. The First Amendment, while it does protect this speech, It offers the defendants a number of rights with regard to this speech. The First Amendment does not prohibit the evidentiary use of speech in this case. And unless this court has any further questions on this issue, I will rely on my briefs for the remainder of the issues and ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
All right, thank you, General Ward. Mr. Jones, you've got about 3 minutes left if you want to make some rebuttal argument.
Sure. Just a couple of things to, I guess, tie things in so that the court is well aware. I do appreciate the general agreeing with regards to the fact that the video was played 3 times. On page 12 of our brief, we actually cite page and location of where they're actually played in full. The lights were dimmed. The effect was created, and we don't believe it was used for an appropriate purpose. We think it was used to intimidate and to basically place fear in that jury, particularly with regards to the question that are posed of what other evidence of gang activity. In fact, Mr. Walker testifies that there is no other evidence of gang activity. And particularly, there's a reference Mr. Ward makes to the argument, to the statement given to Detective Leffler. Bassett, my client, Mr. Bassett, explicitly disclaims any gang affiliation. So there is nothing about gang affiliation in that interview, despite the imploring of Detective Leffler relative to it. And the reference relative to any graffiti, that is graffiti on a fence in a urban neighborhood some ways down from somebody's mother's house. It doesn't have anything to do with it. No time frame given, no who placed it there, nothing with regards to that. So that being said, again, we would ask you to look at Tom Walker's testimony with regards to the fact there is no gang affiliation here. They created a situation where they placed the quote unquote gang fear in through the utilization of this video. It is, in our opinion, protected expression. And that being said, under that set of circumstances, I think when you read that in conformity with the 400 series of rules with regards to the admission of it, we don't believe it was appropriate. I think we timely, vigorously, and repeatedly objected to it. And I think, quite frankly, that that was a big reason of why Mr. Bassett and obviously Mr. Colbert and Mr. Williams were convicted in this particular case, because the state had to have something to create that sort of gang, if you will, aura or fear, despite all of their evidence being that there was no such thing as a gang. And then we got to tie in the 404B as far as, prior acts. Well, there were no prior acts because that was all a fiction. So then why are we using it? If we're going to use it for motive, my artistic expression then can later be used against me, because there is zero proof that anything that occurred in that rap video 7 months before was actually fact, but that in fact was fiction. That's where the strict scrutiny and the First Amendment protection comes in, to protect artists and to not chill. So that being said, we thank our friends at the ACLU for their assistance. We would ask your sage wisdom and that of your colleagues in evaluating this case on behalf of Mr. Bassett, and I'm sure counsel likewise on behalf of Mr. Colbert and Mr. Williams.
All right, thank you, Mr. Jones and General, and appreciate the other attorneys being here as well. All the briefs are well written, and we'll consider the argument today, the briefs, and the actual record, of course, and study it carefully and get an opinion issued in due course. So excellent presentations. I think that concludes it. We have one matter at 3 o'clock. Is that correct?
Yes.
All right, we'll be in recess until then. Thank you, Madam Clerk.
This Honorable Court of Criminal Appeals is now in